morning, Your Honors. May I reserve 5 minutes of rebuttal time?
Certainly.
Thank you. Your Honors, may it please the Court, my name is Autumn Bowling. I'm here on behalf of the appellant petitioner, Alonzo Hoskins. I've been appointed to represent him on this case. I was appointed for the post-conviction hearing and conducted that hearing. Mr. Hoskins comes before this court having been found guilty by 11 jurors of the murder of Jack McFall. And I say this because what we learned in the post-conviction hearing is that when I called juror number 9...
Well, you're kind of being a little disingenuous there. I mean, there were 12 jurors.
There were 12. There were.
I mean,
yes,
she was polled at the time,
And she was polled.
and
so
she said guilty at the time, right?
She said guilty at the time, Your Honor.
So she was found guilty by 12 jurors at the time.
Yes, Your Honor.
Okay.
Effectively 12 jurors. But what we find out in the post-conviction hearing is that her vote was effectively to find Mr. Hoskins guilty of the murders of Channing Christian and Christopher Newsom. So while there were 12 jurors and all 12 voted guilty, what we discovered in the post-conviction hearing is that this was actually a vote for guilty for a different person. And
Is that really what we found at the post-conviction hearing? I'm not sure what we learned from that hearing. I'm not sure exactly what was going on there. Maybe she did sit on the Eric Boyd trial and just doesn't remember this one.
Your Honor, we actually, I went to the jury coordinator in Knox County and had them pull the juror lists and the final juries for both trials. Mr. Boyd's trial was 2 months after Mr. Hoskins' trial in Division II. And what we found, and there was a affidavit by the jury coordinator that the address of the juror number 9 for Mr. Hoskins' case, when we asked her what her address was at that time and currently, they matched, they were the same. And on the juror lists and the panels for Mr. Boyd's trial, there was no juror with the same name. I hesitate to say her name, but
Sure.
They did not match. And so we can, I think, I believe we are able to definitively conclude that the juror who testified, the juror who testified at the post-conviction hearing was the juror number 9 who complained of hearing problems in Mr. Hoskins' trial, and that she did not sit, nor was she even part of a possible panel for Eric Boyd.
Is all of that in the record?
Yes, Your Honor.
So is it possible, though, that she has just lost her memory in the interim time and she's misremembering something at the PC hearing?
I think it's pretty difficult to misremember or just have no memory at all. Especially when she comes in, it's not that she says, I don't remember being on a jury at all. I don't remember, ever voting guilty. She remembers being on a trial. She remembers coming into the courtroom. She remembers that she was convicting Eric Boyd for the murders of Channing Christian and Christian Newsom.
Did she say she couldn't hear the Eric Boyd trial?
I don't think that her testimony was that she couldn't remember if she had complained about her hearing. She couldn't remember that. So when I sent out my investigator, what I initially, to find out what was going on in this at all, was this even a problem? I assumed what we were going to get back was I couldn't hear anything, or I had trouble hearing, the basics. Instead, what I got back was, yes, I was on a trial, and this is what happened.
You got evidence that is different than what you thought you were going to get.
Certainly.
But the evidence that you got sounds like it could be a person who is suffering from, I don't know if she has a memory condition or what exactly is going on here. But at the end of the day, the petitioner carries the burden of proof to prove by clear and convincing evidence that juror number 9 couldn't hear at his trial. And of course, not your fault here. You're working with the proof that you have. But on this record, how has that been proven?
Well, first, I would back up and say that one part of the problem that we have here today is that the post-conviction court's order seems to indicate that it did find clear and convincing evidence, and that this deficiency by trial counsel did call into question the reliability of the verdict in this case, and effectively met the standard.
There's some interesting language in the order, and we can talk about that in a second, but what proof is there in this record that juror number 9 was unable to hear or was otherwise incapacitated in any way during this
Well, and
trial.
let's not broaden this. You didn't raise incapacitation in the post-conviction petition. So that's not at issue. So really, I think getting back to Judge Hickson's question is, what evidence is there in the record that she could not hear and that affected the verdict?
What we have, it is some strained evidence, and part of that is because nobody got to this until about 4 years later. Naturally, there's some memory problems, I think, with anybody. But what we do have, at the very least, one, she had to get hearing aids shortly after that trial happened. She said it was about 3 years ago when she got her hearing aids, so that is about the time after the trial. So we know that there were hearing problems probably right around that same time. I think that's a safe, proper inference to make. Additionally, when I asked her about, do you even know anything about the most basic facts of this case, of Mr. Hoskins' case, which is essentially a drug deal gone wrong with a shooting at a motel? She has no idea. To me, when you have memory and you have, you're able to talk about a whole other case that we know she didn't sit on, and she has the ability to recall things from at least that long ago. It's not a memory problem. It's the fact of the matter is that she never had the knowledge because she never heard it. And instead what happened is I don't want to go too far outside the record, but I think we all are aware of the Christian Newsom cases and how popular they were. And just by the fact that his trial occurred the Eric Boyd trial happened 2 months after this trial, I think it's safe to say it's probably in the news, it's probably in the media, it's talked about in society. I know she denies that she watches the news in her testimony, but if you read this record from front to back from the trial, nowhere in the trial did anyone ever talk about that. So we know it came from outside the 4 walls of the trial. We know that. And so while I don't have a slam dunk where she says, I couldn't hear and I just couldn't hear anything, we don't have that. We have all other indications that she doesn't have a memory problem. She doesn't have a memory problem.
How can you say that?
Because what we can tell, she can remember things from before. She can remember something that was 2 months after this happened.
You're saying she's testifying under oath that she sat on a trial that she didn't sit on. So
And
she's either perjuring herself or she has very serious memory problems.
I think the problem is that she was convinced she was sitting on the Eric Boyd trial based on something she knew outside the courtroom. I'm not allowed to ask her about what information she used to come to her decision, but based on everything we heard, if she would have come in and just said, I don't remember anything. The difference I think we have is that she remembers something. She has convinced herself that she was on the Eric Boyd trial, and that's who she was rendering guilty that day. And that's a huge problem.
That might be entirely true at the time that she testified at the post-conviction hearing. That may be exactly what she believes she did. But getting back to your claim that she was unable to hear at the trial of Mr. Hoskins, a trial that it seems the record reflects she did sit on as a juror, how is that proven in this record?
How is it that she just couldn't hear? I believe it's by linking together all these things that we do have, that she had to get hearing aids very shortly after. She has a memory of a trial, which means she is recollecting events from around that same time. I have to make some inferences and I have to make some assumptions in making this argument. But part of the proof is that she remembers being on a jury, and what happens, I think, is, I don't want to go there, so.
Counsel, is the argument really because she's impaired 4 years later, she must have been impaired at the trial? Is that the argument that you're making?
I think that is fair.
Okay, is that raised at all in the post-conviction petition?
I would think that is fairly raised.
What ground is it?
Well, I think the ground is that this goes back to where the constitutional error about him not receiving a fair trial. That's not the issue we're talking about necessarily. That's the error that is caused by trial counsel's deficiency. This is still at its heart.
I thought the claim, and you'll forgive me, but I thought that the claim was that counsel rendered ineffective assistance because a juror could not hear the proof and therefore deliberated toward a verdict without a full understanding of the evidence. That's what I thought the claim was. What I'm hearing you argue today is counsel was deficient in not investigating the competence of a juror.
I think that's a
And-
very basic way to put it, yes.
And that's not in your post-conviction
Well,
petition as a ground.
Let's read exactly what it is, but what I'm alleging is that originally, so trial counsel is found to be deficient based on the fact that he forgets at the end of all the proof to remind the judge to recall the juror in to investigate this matter.
To
And so
investigate the hearing issue.
about her hearing issue, right?
Okay.
And so when he goes and he raises it on appeal, this court says, that's waived. We didn't have enough information, we have nothing to do here. So the post-conviction court says trial counsel was deficient for that. The prejudice for that is that he didn't get to raise the issue because he didn't go out and get that information.
The
because it was
prejudice
waived.
would be is that his failure somehow affected the outcome of the trial, or there's a reasonable probability that it had an impact on the trial. Not that he would have discovered competence issues 4 years later.
But what he would have been able to do is raise it on appeal, and where this court could have then said, I have the information in front of me to determine on the merits whether or not his right to a fair trial, his Sixth Amendment right to a jury trial was violated. And that was part of the issue that was raised on the direct appeal. And that issue was, by this court, was determined to be waived based on the fact that he did not go and get that information.
Okay, so
There's nothing presented to that.
Are you still
court.
presenting the hearing claim today?
I mean, I think I have to.
Well,
but
whether you
again,
have, whether
I'm
you
not
have, whether you have to or not, I mean, are you? Because I'm not hearing you argue that today. So is that still being maintained, that trial counsel was deficient in failing to remind the trial court about a hearing issue?
Yes.
Okay.
I think it's part and parcel. But in any event, he is found to be deficient for that reason, and by not going, he has nothing to present on this claim, a very important constitutional claim on direct appeal. This isn't just like an evidentiary error where it's going to get a harmless error analysis down the road. This is a core problem. Mr. Hoskins stands today possibly found guilty for being Eric Boyd in the murders of Channing Christian and Christopher Newsom. That is terrifying as a defendant.
Based upon information that arose 4 years later, counsel, I mean, not at the, is there any proof at the time that Juror 9 sat, one, that she couldn't hear all of the evidence and render a proper verdict, but is there any evidence at all that she thought she was sitting on another trial that had not yet happened at the time she deliberated on your client's
No,
case?
because nobody went to find or investigate this information.
Don't you have to show that in a post-conviction hearing, that at the time
I think
that she
this
had
is,
misunderstood the trial she was sitting on, not something that arose 4 years later?
yes, I agree, Your Honor, and I
Okay,
believe that
so
we
what
did in
evidence
fact
do
show
we have?
that.
Okay, you believe that okay, let me make sure I understand, counsel, I'm
I-
sorry. You believe that the record shows that at the time that Juror 9 deliberated on your client's case, that she believed she was participating in a wholly separate trial?
I do, yes, Your Honor.
Based on what?
Based on her testimony that she is convinced that is who she rendered guilty that day. And again, it is a difficult problem, and part of it is exacerbated and it is difficult to argue because, again, we could have found all this out back the day of trial. June 20th of 2019, we could have had all of this settled had trial counsel said, hey, by the way, you said I should ask and remind you to bring this juror in and let's find out how extensive this was. I'm paraphrasing a bit, but that was what the judge said to do. He didn't do that. Because he didn't do that, when he raised the issue on appeal, this court said that issue is waived, we don't have the information in front of us. So had he done this 4 years ago, or more than that now, I believe, had he done this at the time when he was supposed to, this issue could have been put to bed. We would have known what she thought at that time in the trial. So, yeah, I didn't get to this information until 4 years later.
Well, all right, so let me, if I'm playing on this playground now. At the time in voir dire, she's asked specific questions. Was trial counsel in the post-conviction hearing asked, for example, when you received answers from juror number 9 during voir dire, did you have an indication that this woman was incompetent to sit on a jury? Was he asked a question about that?
A similar question, which I think is alluding to one of the other issues, was about during the voir dire, at some point the state thinks that it sees juror number 9 doing something with her ear, I assume, kind of like this. And the state prosecutor stops and says, "Can you hear me, ma'am?" And she says, "Oh, I'm fine." The prosecutor says, "I thought I saw you doing something with your ear." When we talked about that down the road and in the post-conviction hearing, and really what actually trial counsel says when he makes the motion for the mistrial about this, he says, "One voir dire, I took her at her word that she could hear. I took her at her word that there wasn't a problem." So we had raised that as part of the post-conviction, but again, this all feeds into this, I think, what is the large core issue, which is because he didn't ask her to stay afterwards, Mr. Hoskins lost all ability to challenge this. And yeah, I'm here 4 years later and I have to deal with the fact that I'm dealing with a 4-year gap in time. Anybody is gonna naturally have some different or less memory. But I believe that what we have in here is clear and convincing enough, especially when what's on the line is a constitutional error. And I don't mean the ineffective assistance of counsel, but what was ineffective about trial counsel was caused a constitutional error. His right to a jury trial has been violated. And I don't want to blow into my rebuttal time too much, so I'll go ahead and hand it over.
Counsel, is there a standalone violation of the right to a jury trial in the post-conviction petition?
Not from my understanding, Your Honor.
Is there a claim that trial counsel failed to investigate the competence of juror number 9?
No, I don't think it was competency. As I understand it, Your Honor, the claim that we're here to discuss today is whether petitioner's trial counsel was ineffective for not renewing a motion to bring in juror 9 to determine what she had or had not heard during that first day of trial. She made the complaint, just for context purposes, just before the second day of trial. And I'd like to, if I may, discuss prejudice first, because I think that is important, but also at some point I'd like to come back and talk about deficiency, because I don't think trial counsel was deficient at all. Again, I think, as the court has alluded to, what we have here is juror 9 expressing a memory issue at the post-conviction hearing. What we don't have any evidence of is a significant, substantial, or have any knowledge of the extent of a hearing issue at petitioner's trial. And I think it's important to underscore that we actually have affirmative evidence that this is a memory problem at the post-conviction hearing. The reason I say that is that the facts of this case were relatively straightforward. It was a drug deal gone wrong. It was a shooting that took place in the parking lot of a hotel, and there was surveillance footage that captured from multiple angles this crime, and I think captured it quite clearly. And so it's also important to note that this footage was played many times throughout the 4-day trial. And I think what the footage shows, or would have shown to anyone, even someone who couldn't hear at all, is certainly that there was a shooting, that it occurred in a parking lot, and maybe even that it was near a hotel. So the fact that juror number 9 couldn't remember even the most basic or fundamental facts of the case, facts that were established by visual evidence and not auditory evidence, I think affirmatively establishes that this was just a memory problem at the post-conviction hearing and not necessarily a hearing issue at trial. The other fact I would note that affirmatively establishes that this was a memory problem at the post-conviction hearing is the fact that juror 9 was asked, "Do you recognize petitioner?" Juror 9 says, "I've never seen that man before." Regarding his name, she says, "I've never heard that man's name before." Particularly as it relates to recognizing petitioner, again, 4 days of trial, petitioner presumably was sitting in during the trial, and juror 9 had many opportunities to observe the petitioner, and yet she claimed at the post-conviction hearing that she could not recognize petitioner and had never seen him before in her life. So there's just simply nothing to establish prejudice here. There's simply no evidence that we have that this was anything more than a memory problem at the post-conviction hearing. Turning back to deficiency, I just want to recontextualize things and when this volume complaint was made, it was made before the second day of trial. Defense counsel catches wind of this complaint and moves to question Juror 9. At this point, petitioner's trial counsel and the court have an extensive back and forth. Essentially, what petitioner's trial counsel refused to do was accept no as an answer. The court was clearly disinterested and continually said no and to bringing in Juror 9 for questioning, and petitioner's trial counsel just kept pushing, said, Your Honor, let me make a record, let me do this, let me ask more. Petitioner's trial counsel moved for mistrial and then sought to renew the motion, said, hey, can we talk about this after trial? That's important to understand because I think it establishes first regarding deficiency that counsel was not ineffective or not deficient because he acted as a zealous and effective advocate. Just to broaden the context even further, sort of give an even broader scope here, during the trial, there were 17 witnesses. It was a 4-day trial, again, as I've mentioned. It is clear from reviewing the transcript that petitioner's trial counsel had a nuanced understanding of the facts, used prior and consistent statements to cross-examine witnesses to try to further the trial strategy, which was to undermine the state's witnesses and their identification of the petitioner. What these acts show is because of this zealous advocacy, his one admission during the post-conviction hearing that he forgot to renew the motion to bring Juror 9 back in, that doesn't outweigh his otherwise good counsel. So on that point, I would just say his advocacy generally was quite strong and quite effective, and he was quite zealous in advocating when the volume complaint arose initially. For those reasons, I think that he was not deficient. I think what is even possibly more important is my second argument on deficiency, namely, this court has held consistently that bringing in jurors after trial is a disfavored practice. And so, as I understand petitioner's brief, the deficiency alleged here is that trial counsel should have pushed even harder to bring in juror number 9 for questioning. Again, this court has said on no uncertain terms that such post-verdict inquiries may lead to harassment of jurors, inhibition of jury deliberations, and undermine the public's confidence in the outcome of jury verdicts. And it is also suggested that issues of incompetency or inattentiveness are similarly not good reasons to bring in a juror for questioning after trial. So I think that is a separate, independent, and very strong reason for finding that petitioner's trial counsel was not deficient. And I think to find otherwise would incentivize precisely what this court has previously discouraged.
How else, let's pretend or assume that this juror couldn't hear anything that was going on during the trial. How else would trial counsel have shown that other than asking the juror?
I think it would have been possible to bring in potentially the court officer. This volume complaint was relayed from juror 9, presumably, although we don't really know that, to be honest, because juror 9 couldn't even remember complaining about volume at the post-conviction hearing. Juror 9 relayed this information to the court officer, who then relayed it to petitioner's trial counsel. So potentially the court officer could have testified. It's possible, maybe even probable, that if there were significant hearing problems during the trial, that other jurors could have testified or been brought in to testify.
Were there some other complaints from other jurors saying they were having trouble, or did I misremember?
Your Honor is correct. There was a subsequent volume complaint made by a few jurors. However, that didn't have to do with the witnesses. They said specifically that they were having trouble hearing petitioner's trial counsel. And at that point, the court said, well, we'll just remind him to speak up. There's no indication that juror 9 was among those. And again, I think as this court mentioned earlier during one of its questions, because of this volume concern, the jury was polled, and there were no issues discovered during jury polling regarding any hearing issues or issues of unanimity.
Going back to something you just said, that the counsel was told, I guess, by the judge, or at least the judge indicated, hey, after the trial, we can perhaps address this issue again. Okay, so, I mean, were they contemplating, or is it even clear from the record, contemplating, okay, we've heard all the evidence, we've had argument of counsel, you've heard jury instructions, now juror number 9, you need to stay here because we're going to talk to you about whether or not you can hear, or were they going to wait until after the verdict came in, or was it really clear on the record even what they were talking about, or how they were talking about doing it?
You know, it's not entirely clear from my reading of the record. I think it would have been a post-verdict discussion, as I understood it. It's also important on that point, Your Honor, that from my read of the record.
Have a juror come in after they rendered a verdict to ask them questions right the same day?
That's, from what I understand, that's what was proposed, Your Honor.
Well, what was the finding of the post-conviction court, though? So the post-conviction court made a specific finding that trial counsel was deficient. How did the post-conviction court find the deficiency?
I think it said in what I would describe as sort of conclusory language that trial counsel is just forgetting to re-raise the issue after trial was just deficient. I don't know that there was a whole lot more explanation than that.
So the post-conviction court's not discussing manner or necessarily even timing, just the failure, the complete failure to do it was deficient performance.
Yes, Your Honor. That's how I understand the record.
General, I'm sorry. Can I ask you about that deficiency finding? Because if I'm reading the post-conviction court's order correctly, I believe the court said that the trial court's failure to renew the inquiry, or trial counsel's failure to renew the inquiry, deprived the defendant of a fair trial and called into question the reliability of the outcome. I think that's something Ms. Bowling was going to touch on before I interrupted her with a barrage of questions, and I'm sure she'll get into that on rebuttal. What do you make of that language? It sounds like the PC court's quoting the prejudice standard that would be a successful showing of prejudice.
A few points on that, Your Honor. One, I would say that, yes, the post-conviction court cited the Burns case, and its order was initially unclear. But what is remarkably clear from the court's order, ultimately, it says petitioner had failed to, quote, make a showing of prejudice, close quote. It also stated that juror 9 did not testify that she had, quote, missed a large portion of proof in the underlying trial due to a hearing issue. And so the court refused to, quote, speculate that juror 9 missed portions of the proof due to her inability to hear, close quote. What the trial or the post-conviction court clearly concludes, despite its initial lack of clarity, is that it was denying the claim based on a failure to establish any evidence of prejudice. It's also worth knowing that this court's application of the law to the facts is de novo, so this court is entitled to address that issue on its own, of course. And so I would just say, yes, it was initially unclear, but the court denied the claim, and it's clear that the basis for the denial, it made it explicitly clear that it was a failure to establish any prejudice. Unless there are further questions, I ask that you affirm the trial court's or the post-conviction court's ultimate conclusion and deny post-conviction relief.
So first, to address the deficiency issue, I think the post-conviction court is quite clear why there was deficiency, and in reading directly from that order, Mr. Lowe did in fact perform deficiently by failing to renew his objection to juror Maynard not being questioned by the trial court, and again, talking about what didn't happen. That did not occur, and the matter was therefore waived on direct appeal. This court finds that trial counsel's failure to renew the inquiry by the trial court of the juror deprived him of a fair trial. I think that's pretty clear why it is. He wasn't able to bring that issue on to direct appeal. This court said it was waived. That makes him deficient for not bringing it. So I think that addresses that point by the state. talking about the trial court that trial counsel seemed to refuse to take no for an answer, and that the trial court seemed disinterested in that. I don't believe that's correct. In the motion for new trial, the trial court said in relation to this issue on not allowing him to call juror number 9 at some point, let's see, he said, the court will make an inquiry to see how much, if there's been an extensive amount of trial that a defendant was unable to hear. I don't find anything in my notes to indicate that anyone expressed that they had missed any kind of substantial amount of trial. So it does appear that the court seemed like it would have been interested, didn't have notes that it had let anybody, that it had any information like that, and that's because back then at the trial, he didn't let anybody come in and testify. And in talking about calling the officer, my recollection from the record, and I couldn't pull the exact site number from it, but the motion for mistrial during trial was that trial counsel said, well, can we call the officer? And the trial court said, no, we're not going to call anybody, we're not going to do this. And then again, getting to the motion for new trial, the same judge, there wasn't a change in judge at any time. And so the same judge says, well, I don't have any information about that, and I would have let you do this. And so there seems to be some conflict, and again, there's a memory issue now too. And so I think that to say that this was the court was disinterested in it or never would have let it happen, we have evidence that he would have let this happen. As far as this being a disfavored practice, I think he's right about the law. It is a disfavored practice, but disfavored doesn't mean that you don't do it when it's time to do it. There are those rare cases. And this is not an issue that was just born out of whole cloth, when I'm investigating this 4 years later. We knew the trial started on June 18th of 2019. On June 19th of 2019, we knew there was a problem with a juror being able to hear. And it was never addressed, and it was never looked at. And when I say never addressed, I mean there was never a hearing to confirm, did you really miss a lot of trial, or could you just not hear a witness? And I do think it's important as to the possibility of the amount of witnesses she may have missed. She may have missed up to 35% of the witnesses by just not hearing anything on the first day. And that's just by the number of witnesses that were testified, or that testified during trial. And I think, again, what gets to what the court said in its order, and why I believe that the court did conclude that that we established prejudice. I believe what happened, as I read this order, is that the post-conviction court has said you can meet Burns, you can meet the Burns standard, but even if you meet that, there's still a possibility that maybe you didn't meet Strickland. And that's not correct. If you meet Burns, Burns is just a simpler interpretation of the prejudice prong of Strickland. So if you have met Burns, and the court has said that we met Burns, it is the quote that is what the post-conviction court quotes when it says as much, we have met Strickland. And so really all we're coming in to say is you got the ultimate conclusion wrong, because earlier in your order, you found that we met the prejudice prong. Again, this is a serious, I'm not raising on its own constitutional issue about the juror competency, and that I am raising that this was, trial counsel was ineffective for failing to bring back in the juror to establish what we all want to know. What was she hearing at that time, if anything? What was she thinking? And because trial counsel did not ask for her to stay afterwards, this court later found that because it had no further evidence to show as much, that issue was waived and could not be reviewed on the merits by this court. And that caused him to be, this deficiency has prejudiced him because he wasn't able to develop the evidence and the testimony needed, and especially at a time very close in time. Again, I don't know what day exactly they wanted to do this, but it does seem to indicate it would have been, right after trial. In any case, it would have been a lot closer in time with a lot more, we wouldn't have to have I wouldn't be getting these same questions about her memory loss at that time. And so it is trial counsel's ultimate failure to not cause this that, one, causes him to not be able to raise this issue on appeal, but now I don't have the right evidence. And I think that we could have gotten and either put this issue to bed or remedied this much earlier in time. And that is the ultimate problem here. And so we ask you to find that trial counsel was in fact ineffective, both deficient and prejudiced to the defendant. Our petitioner appellant asks you to remand this case for a new trial. If there are no further questions.
Thank you.
Thank you.
Thank you, Your Honors.
Thank you, counsel.
We'll be in recess then until 1:30.